Well, the trial for convoy leaders Tamara Lich and Chris Barber has gone on break until after Thanksgiving. Lich and Barber are facing a number of charges, multiple charges, including mischief and obstructing police for their actions during the so-called Freedom Convoy back in February 2022. The trial was originally scheduled to last only 16 days, but so far it has only heard from 4 of the Crown's 22 scheduled witnesses. Well, for more on how this trial has unfolded so far, I want to bring in Michael Kempa. He's an associate professor of criminology at the University of Ottawa. He joins us from the nation's capital today. Michael, welcome back to the program. I know we spoke to you a number of times during the actual convoy protests as well. What is your take here on how the Crown has presented its case so far?
I think, like many people, I'm quite confused. We knew that this was a case of extreme importance. We know that charter issues are going to be raised, certain charter issues that do not have a lot of previous jurisprudence, so very high profile, very important. And it does seem that the Crown has stumbled a little bit out of the gate in terms of not having all of their disclosures properly organized and presented to the defense in good time, in terms of not having all of their witnesses adequately prepared. They didn't have their notes and so forth, which resulted in further delays. It's getting to be a problem, and we're starting to hear rumblings from the defense that they may seek a dismissal on the basis that the right of their clients to have a trial in a reasonable time frame is not happening.
That seems to be, an issue for the Crown for sure. What do you think has been their biggest misstep so far?
It just really seems to come down to lack of organization of presentation of the evidence and explaining the logic of the reams of evidence that they want to include, such as social media postings, such as testimony from witnesses of people who live in Ottawa, and making it clear to the court and to the defense what the purposes of all of these volumes of evidence in fact is. It's a bit like having loose threads. It's the job of the defense to pull at every single loose thread that the Crown prosecutors offer, and so far they've offered very many.
Michael, the trial, as we said, is on a break, but the parties are going to meet again on Friday. So what are they going to be discussing there?
Well, Friday's going to be a bit of this housekeeping where the defense has said, we want to be very clear now, have the Crown give us a plan for exactly how much more time they're going to require, with evidence and what people they'd like to come in as essentially witnesses, so that we have a sense of how long this is going to go. I think you can see that as the defense is really exercising its due diligence. It's showing that it's trying to act in good faith, because then if there continue to be delays, they're on stronger footing to ask for that dismissal. It's called a Jordan application, to make that Jordan application saying this is not happening in a reasonable time frame, despite our best efforts.
Is there danger, Michael, that this trial won't get to sort of those bigger issues that it needs to address because it's been bogged down in all of this?
Well, one thing that we've just heard, initially, as you say, we were here for 16 days, and then the court was talking about booking 2 more weeks. Now we're talking about 4 more weeks, and I can't really imagine that they'll include very many more days beyond that. These will not be consecutive weeks. We might get a couple in November, and then we'll have 3 or 4 days here and there, possibly even going into the new year. If we don't get moving, the defense will start pushing for that dismissal. And the real value of this case, whether you're for or against the Freedom Convoy, whether you want a conviction or you don't want a conviction of Tamara Lich and Chris Barber, is to settle those issues of the balance of charter rights to assembly versus ordinary property rights for people to use public property for their daily business. In other words, this is the basis of the mischief charges. How do we strike that balance? If we don't get there, this trial will have basically been a horrible waste of time.
Michael, I want to dig into that exact point before I let you go, because sort of what is at stake here if this trial doesn't proceed and get to those bigger issues?
Well, it would bring the administration of justice into disrepute. This is not the type of case that a Crown prosecutor would be very eager to take on, because it's very difficult to prove issues of mischief and obstruction and so forth in the instance of an absolutely enormous protest. Now, we might say, well, it looks like the advice of Tamara Lich or Chris Barber caused people to do things in Ottawa. but you actually have to prove it. And it's to that very highest standard in a criminal case of beyond a reasonable doubt, unlike in civil litigation where it's only on the balance of probabilities. So they have to take the case, though, because it is in the public interest to get to these questions of the balance of the charter, those rights to assembly and expression, versus everybody's rights to access public space for their daily essentials, like going to work and getting medication and so forth. If they don't do it, in fact, the administration of justice will end up looking quite silly.
Michael, thank you very much for your time and as well as your perspective today. Michael Kempa is an associate professor of criminology at the University of Ottawa.